right quick. All right, this is Trump and the GE. I'm Shock Exchange, of course, and today we're going to discuss the pretrial motion in Trump's RICO case in Georgia. This is probably one of the most talked about cases in the country. It's probably of all the cases against Trump that are remaining. It seems like it has legs and a real opportunity to have Trump indicted or the co-defendants indicted, if you may. It's being led by District Attorney Fani Willis for Fulton County, Georgia, and she's been under attack for alleged impropriety involving her and her boyfriend, her former boyfriend, Nathan Wade, who was a special prosecutor on the case. The defendants are saying that it's a conflict of interest to have her boyfriend on the case, and that the whole case is basically trumped up charges against Trump for them two to get publicity and earn hundreds of thousands of dollars for themselves. That he's been paid over $750,000, and it is new to her benefit because he spent lavishly on her and helped fund her lavish lifestyle. So she's personally benefiting financially from the case and also from a lot of publicity from these trumped up charges, which is illegal, according to the defendants. Judge Scott McAfee's ruling was that either Fani or Nathan Wade recused themselves because optically didn't look appropriate. Nathan Wade left the case and Ms. Willis remains. Now Trump his lawyers are saying that she should be disqualified altogether because it was improper. Her role on the case is improper, remains improper, because she's benefited financially. So now there's a pretrial motion to get her off the case or even get the case dismissed. And I'm gonna let you listen to a few minutes of Steve, I think his name's Steve Sadow, the defense attorney who's becoming like a legal superstar based on his legal acumen, shall we say. He's becoming real popular with the press, and I think some of this case that hinges on the argument hinges on whether it's Trump's political speech is protected, whether it gets First Amendment rights. His political speech, I guess, during the election results and after the election results came out, whether it gets free, whether it's protected by the First Amendment. So here goes. I'm going to try to share my screen.
Sense. The mere fact that it's false is all that they have. There's not a finding that the speech itself, beyond the speech itself, is fraudulent. What the state wants to do is say, we have a goal. We have an objective here that we have put forward. Steal the election in an unlawful fashion. I say change that for a second to legitimate concern about the validity of the election. If that was the way you focused on it, which is a way to do it as applied, even with the facts, would what President Trump said on those counts be a protected speech? And the answer is it has to be.
Okay, this is important, where the state is saying that, Trump and his defense attorneys are saying that he has a concern about the integrity of the election. That's why he raised concerns about the election results, that the results seem kind of squirrely, and he has a right to challenge the election results and the integrity of the election process, the vote counting, and the election results. And the state is saying that his speech was an intent to steal the election. So that's where the rub comes in, apparently.
Because the only thing that makes it fraudulent is the state saying it's false. Take every one of those and say, okay, it's not false. It's protected. The only reason it becomes unprotected, in the state's opinion, is because they call it false. And that's what Alvarez doesn't allow. In and of itself, it cannot be simply the content-based. It has to be contextual. And the contextual here is a political core value being addressed, elections and campaigning. And that holds true for all of those that deal with the conspiracy. And then you deal with counts 29 and 39, which is the false statements charges. Now, it is clear that the Supreme Court would find that a statement made under 1001, 18 U.S.C. 1001, would constitute the appropriate, let's say, abridgment or non-protected conduct or speech. But Georgia statute's a little different here, because we don't have a materiality element. It's the mere fact of falsity, which violates, according to Georgia law, counts 29 and 39. You don't have to do anything else but make a false statement, even if it is political discourse, even if it is in the heightened context that I've suggested. If it's false, it's a violation of the law. And I'm saying, as applied to political speech, that can't be.
You're starting a business because you're great at
Constitutional as applied. Remember, no materiality, simply the fact that it said it. So essentially, what the state's position on that would be, it didn't have to be sent to anyone of consequence in the state agency.
This is also an important point because Sadal is suggesting that there's no materiality threshold in the state of Georgia for a false statement, where the Supreme Court, there appears to be a materiality. So either this is something that could go to the Supreme Court and get overturned on appeal, or maybe Georgia needs to change its statutes to be consistent with that of the Supreme Court. I'm not sure, but he's saying that there's seems to be saying there's a discrepancy between Georgia state law and laws and case law from the Supreme Court. And again, this could be like a 100-year event. Like, how many times does somebody challenge an election results, and get brought up on charges for this? This is like a 1 in 100-year event. Appears to be. Very unusual case.
It just had to be said. Indeed, if you look at, and the most probably best example is count 39. That's a letter written after the election in September of 2021 from President Trump to Secretary of State, in which it has, according to that, one statement. And that constitutes, according to the state, falsity, but it's clearly political speech. And it's clearly being related to the activities and the matters that of election and campaign, even after the fact. It's still related just to that. So looking at 29 and 39, I think you have a situation in which the falsity alone is all they have as applied here to political speech. It is unconstitutional as applied under the First Amendment. And then finally, you have count 27.
Quick question on that. Had you, I hadn't located one. Had you found anyone ever attempted a facial challenge on 161020?
Yeah, in fact, I don't remember the name of the case, but it has been upheld, even though there was references to the fact that maybe materiality should be part of it.
That's got to be the Haley case. That's right. That's right. Okay.
So, yes, facially, yes. But Haley, of course, didn't go to the extent of trying to determine as applied in a particular context. And it's, again, I don't to repeat what I just said, but here we're talking about the heightened value of core political speech. And then with 27, we're talking about the filing of a false document. Again, the only thing there that involves President Trump is an attestation on the complaint. Now, all it refers to in the indictment is complaint. But again, we're talking about the act, the falsity, or the filing of a false document is the falsity in the document itself. And I'm suggesting under the circumstances, that and that alone wouldn't violate that statute as applied. So regardless of the facial challenges, the question becomes here, is the mere fact that the state says fraud or false statement enough to get by an as applied challenge? And our suggestion is it is not. Now let's go to RICO. And I think RICO is more difficult, to be honest with you, because we're talking about a much broader statute. At the same time, when you look at the allegations against President Trump, all of the allegations involved expressive conduct or speech. We have false statements alleged in overt acts, and again, all of which are political core value, political discourse. You have false statements in overt acts 1, 5, 7, 8, 17, 93, 97, 108, 113, 133, 135, and 157. Purely, the only allegations there are falsity. There's no allegation beyond the fact that those statements are made. And I'm suggesting that, again, heightened political speech has to be looked at differently. When it comes to tweets, which is, at least the way the state sets it forth, is also political speech, and here certainly by the then President of the United States, you have tweets in 22, 26, 27, 32, 75, 100, 101, 106, 114, 128, 138, and 139. So the majority of the overt acts involve false statements or tweets which are clearly political speech. How best to deal with that?
Okay, so I think he pretty much laid out the case from the defense's perspective that it hinges on a couple of things. The state is saying those statements are false from President Trump. The tweets, now everybody knows the tweets can be brought into can be used in court against you. That the tweets are false statements. The statements from Trump, the political speeches, are false statements because the state says they're false. They're false because we're the state and we say so. Almost by fiat. And the defense is saying this is political speech is protected by the First Amendment. The other thing the defense is saying is that he's challenging the integrity of the election results, the vote counting, and maybe the process for which those votes were counted, especially during a pandemic or coming out of a pandemic when there were so many mail-in votes, probably unusual amount of mail-in votes because people sitting weren't coming to the polls in person, maybe because out of fear of COVID or the pandemic, what have you. And so maybe those election results seem rather squirrely vis-a-vis other election results in prior years. So he was challenging the integrity of the election, which is his right. The state is saying that, he was challenging the election results, but his intent was to overturn the election. And state went on to say later on in those hearings that that case rests on the intent, and the state says intent behind Trump's speech was to overturn the election, and the people more qualified to determine intent would be on the jury. The jury is more qualified to determine intent than the state or the defense attorneys. So it's premature to say what the intent is right now. The only way you can determine intent is to put it in front of a jury. And that's the state's position. So will this be overturned? I'm not sure, because it's kind of scary where you can challenge the election results. You can challenge the integrity of the election results according to the law. However, the state can also say that your challenge was an intent to overturn the election. So anyway, a grand jury has listened to the evidence and has felt that there's enough evidence to go to court. I'm not sure if it's bifurcated between Trump's political speech and maybe some activities of the other co-defendants who were actually on the ground in Georgia and making moves and doing things that could be considered illegal. So there you have it. Will this be overturned? I'm not sure. But that's sort of legal gamesmanship that's going on between the defense and defense attorneys and the plaintiff's attorneys and the state. So we'll see what happens. But just worst case scenario for the defense is that, they're going to trial. So that's Trump and the GE. Thanks for listening. Thank you.